Stay tuned for another edition of Zoom Landlord Tenant Talk Radio. The opening topic today will be common tricks played by tenants. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio. It is September 21st, 2024. And as you know, we do this every Saturday at 3 p.m. The song today was Always Remember Us This Way by Lady Gaga. It was featured in the 2018 movie A Star Was Born, and just one beautiful song, and was definitely a mega hit. Before we open it up to questions and answers from everybody who's on the Zoom meeting, and I do see we have a lot of people already, we always start with a topic. The topic today is common tricks played by tenants. Common tricks played by tenants. Let me tell you something. It's a war out there, ladies and gentlemen, and I'm on the forefront of it. And between landlords and tenants, and the harm that a tenant can do to a landlord is exponential in terms of what his monthly rent can be. If you get yourself a bad tenant, or once the tenant's in possession, he stops paying the rent in order to go through an eviction process, even as quickly as it can go. Right now in the county of Los Angeles, sheriff's offices are taking 2 months. So that means any eviction is a minimum of 3 months before the tenant does play any games. Of course, if they play games like filing for jury trials or contesting the proceedings or filing motions, then of course this will elongate the process. So just think of yourself being without rent for 3, 4, 5 months, having to pay a law firm such as mine, fees to rid yourself of this bad tenant. And last but not least, the condition of the premises once you finally regain possession, and what it's going to cost you to rehab it and then finally to rent it out. It's astronomical, $20,000, $25,000 just because you made a bad decision. And there are tenants out there that are looking to prey upon landlords. They have tricks after tricks. So I have kind of categorized them for this Zoom meeting today. And take notes, ladies and gentlemen. And if you find yourself with a tenant playing one of these games, you know what you do? You turn and run immediately. So the tricks come in 2 different stages. One is prior to possession, and then once in post-possession. So let's talk about prior to possession. This is when you're going to have an applicant who shows interest in your rental and wants to take it. So common trick by tenant is when you ask to see their driver's license, and they'll show it to you, that it could be a fraudulent driver's license. It is so easy today to get your picture and someone else's name on a driver's license so that you think that the person standing in front of you actually is the name on that driver's license, but the truth is it's not. It is so simple in this day and age to get a driver's license that has counterfeit. So I always ask tenants, and I recommend to my landlords, that to establish the identity that the person really is giving you the correct information, ask the tenant also, not only do I want to see your driver's license, I want to see a few bank statements. Now, nobody who's fraudulently trying to steal the identity of somebody else is going to have their bank statements for the last few months. Only a real person. So this is a proper question. And the proper question is, okay, I need to establish your identity, that you're really the name that I'm seeing on this driver's license. And so I need you also to bring with you, when you come down to fill out an application, I need you to bring some bank statements with you. nobody other than the true person is going to have that bank statement. Now, the next thing you want to do is you want to obviously have them fill out an application. Do not rely upon the numbers, the phone numbers that they put in that application. So if they say they work for an employer and you're ready to call that number, what you don't know is one of the tricks is that they will put down a friend's number next to the name of the employer. So you'll call that number, the person answers and says, yes, this is Ralph's Market. And then, of course, they'll give you all the information that you want to hear, but unfortunately, none of it's true. So in that situation, make sure that you call Ralph's Market directly, get their information from a Google search or online someplace where you're not relying upon the phone number that the tenant has supplied. The next thing you want to do is if they're on their application, they're obviously going to list the name of their previous landlord and maybe a few before. I'm going to ask my tenants to bring proof that you've made payments with this landlord for the last few months. I want proof of payments. I want to see copies of checks. Now, again, if in fact they haven't paid rent to their last landlord or they've been evicted, they're not going to be able to show you proof, okay? So always ask for proof of payment for the last 4 months from their landlord. If they don't have it, guess what? Time for you to walk, ladies and gentlemen, because this is another trick that's being played upon you so that they get entrance to your building. And you know what that means when they get entrance to your building. You're going to be out $20,000 plus. I kid you not. When you're reviewing their application, you want to make sure that there are no gaps in their rental history. So for example, if it shows that, oh, well, I was here in 2018 and here in 2020, and then here in 2021, but then all of a sudden there's a gap for 23 or a gap for 22. Well, what happened? Well, I can tell you what happened. In all likelihood, the guy was getting evicted. So he's not putting that source down. So look for gaps in their rental history. Now, as usual, when you see your tenant, you're going to give them an application. Well, I've kind of beefed up my application. So what I want to do is I want to show it to you. It's online at my website, which is evict123.com. That's evict123.com. Go into the free forms section and go down to where it says rental application. I want to share this with you. Let's take a look right here. And okay, so this is my rental application. It's actually fillable, so you can actually email it to your tenant so he can fill it out prior to actually meeting you on the property. And you'll notice that it's pretty extensive in terms of what we're asking for. So this is, your personal information, who's going to be living there, like your children, rental history. That's where you want to see the gaps, who they're employed by. Okay, remember that you're not going to rely upon their phone number. You're going to check it out yourself. You want to see other sources of income and vehicles. But then we get to these wonderful questions. So let's go to these questions. Have you ever been evicted? Well, if they say yes, then you know what? You're not going to allow them into your unit. Have you ever been convicted of a felony? Okay. If they say yes to that, then they need to fill in. Now, you can't just summarily, under the new housing and urban rules that have existed for the last few years, you can't just say, oh, you've been convicted of a felony, so now you can't move into my building. You have to find out what the felony was and how long ago and whether it would have any current reference to your building now. So if somebody, for example, had a drunk driving felony, 20 years ago, you can't use that to summarily reject their application. Here's one. Have you ever filed for bankruptcy? If they have, I would stay away from them. I don't care what the circumstances are. If they file for bankruptcy, I believe bankruptcy is moral theft. And on that basis, I wouldn't rent to them. Do you currently smoke? Well, every rental agreement like mine, which is online again, says, do you currently smoke? If they do, you're not renting to them because you can't have people smoking in your building anymore. The next question would be, do you have any pets or animals? If they say yes, okay, you want to find out what kind it is. Maybe your pet building is a pet-free building. Unless they're telling you that they have an ESA, an emotional support animal documentation from a medical professional, then you don't have to let them in. But here's some interesting ones. Has a landlord ever asked you to move? Would you really want to take a tenant where in the past the landlord said, you know what, I've had enough with you? If any landlord on this planet felt that you were not a good tenant, that's good enough for me. I'm not going to rent to them. And last but not least, in the past 5 years, how many lawsuits have you filed and how many lawsuits have you been involved in? Okay. And the reason for that is, do you really want litigious people moving into your building? Is that what you want? So you want to make sure that people are trustworthy, are moral, are going to treat your property with respect. And the front line of doing that is to get yourself an application where it's going to ask these questions and go through it very diligently, okay? Very diligently. Okay, let's stop sharing the screen at this point, and let's go back to me. The next thing you want to do is you want to run a credit report. That is mandatory. Many of the apartment owners association have them as part of their services. I know the Apartment Owners Association runs a great report, and you want to make sure that you run that report. Now, I just had an incident with someone who I know on a very close level who asked me not to bring up this person's name, so I won't. But this person was confronted with an applicant and said, listen, you don't have to run a report, a credit report. I just ran one and I'm going to be purchasing something else and I don't want my credit score to be lowered by running a credit report. So here's this accurate and fresh credit report. Ladies and gentlemen, that's code words for I'm going to screw you. That credit report in no uncertain circumstances will probably be fraudulent. You need to always run your own credit report. Do not take one that the tenant is supplying with you. If they do hand you one, throw it in the garbage. You must run your own. When you do the credit report, you obviously also want to see if there's an eviction report, how many times the person's been evicted. But of course, in this state, it's very difficult to determine whether somebody has been evicted before because our wonderful state legislature has created rules which basically hide evictions in most cases, unless you were lucky enough to get a judgment against your tenant within the first 60 days of filing the lawsuit. So in most cases, it's going to be hidden. So, but I would still run that eviction report along with a credit report. But another thing that you should do, and that you can go to any of the county online courthouses, do this online, and you can run a plaintiff defendant search. You want to see whether your tenant, and that's one of the questions you ask, has been involved in any lawsuits. Do you really want to have a tenant move into your building that has sued the last 4 landlords? And maybe for habitability claims or something like that. I mean, or do you want to be involved where somebody keeps suing this tenant? Well, even if it's just regular people in business, well, if other people are suing him, I think that's a bad risk for you and your building. And listen, do not be desperate, okay? I know you want to rent out your units. I know what the stakes are. But again, if you get somebody in your building that is not good, then quite frankly, it is far better to have a vacant unit than to have a tenant in that unit who's giving you trouble. Believe me. Okay, so check court filings. Again, you can do this yourself, or the Apartment Owners Association will also do that for you. And then listen to your tenants and what they're saying, okay? This is very important, ladies and gentlemen. if the tenant says to you, by the way, is this property professionally managed? You know what that means? It means he's trying to get you. And he's asking that question because he knows if it's just a mom and pop situation, then you're not going to have the same due diligence as a professionally managed place. So watch that. If anybody says, is this place professionally managed? Well, that's code words, ladies and gentlemen. Also, watch it when the tenant states, you know, I really need to get into this place quickly. I have all the cash that you want. Here it is. I'm ready to move in. I'll take it as is, just the way it is. I got to get in by tomorrow. Ladies and gentlemen, that means I'm evicting that person. That's why they got to get in quickly. Somebody's after them and they got to move quickly. If that's the case, stay away from these people. Okay. That's all the tricks that tenants pull prior to possession. But what about post-possession? Post-possession, they were already in. Well, let me explain something. Do not listen to tenants' stories. Pretend you are deaf. When they start talking about hard times, they lost their job, they're getting divorced, there's sickness or death in the family. Okay, this is not your problem. It is not your problem. You are running a business. In terms of being charitable, I've said this before, certainly be charitable. Be charitable to your children, close family members, and the City of Hope. That's it. If you're in business, you got to run it like a business, okay? You don't want to get involved with stories with your tenants. You don't want to be buddies with your tenants and go on fishing trips. You want to treat this just as what it is. It's a professional business relationship. If the tenant doesn't have the rent to pay, you must take immediate action. Do not listen to stories. Do not get comfortable allowing a tenant to pay late rent. And if you have a provision in your rental agreement that provides for late charges, a legal provision, enforce that provision. You must treat this like what it is, and it is a business, okay? Now, once tenants are in, and even if they're paying the rent, you become susceptible to being sued. Doesn't matter what you do, you become susceptible and sued. So many of these unscrupulous tenants' attorneys are filing habitability lawsuits against landlords. And there's really very little way to prevent it. You could be the best landlord in the world, but they're still coming after you. They just see deep pockets, they see your insurance company, and they just want to come after you. Some ways to avoid that would be to make sure that there's a provision in your rental agreement that states that all repair requests must be in writing. If it's not in your rental agreement, I have that in my free form section. It's called a notice to change the terms of tenancy, requiring that all repair requests are in writing. This way, when the tenant alleges that you're a slumlord and that you never took care of the building, even though he asked you and asked you to do so, you have proof that he never did it in writing. And also, you must keep accurate records of all interactions with your tenant. So when a tenant sends you, you know, you never fixed the garbage disposal, I would immediately write him a letter back and saying, by the way, this is the first time you ever mentioned the word garbage disposal, and I immediately sent somebody over to repair it or replace it. Keep all of your conversations as a record, because this will help you when you get sued. And trust me, they're coming after you, ladies and gentlemen. They're coming after you. So you want to keep good rental records. You want to document all interactions with your tenant. This will save you when you get sued. These are the tricks tenants play. You know, they'll call the health department, they'll complain about something, and they never asked you. Well, if you keep good records saying, hey, first of all, you had to put this in writing to me and you didn't. And secondly, you can see the history of whenever you did ask for something, I immediately took care of it and I immediately confirmed it in our correspondence together. Keep accurate records, send correspondence to the tenant saying, very funny, that you called the health department without first calling me. Please call me first. Or why are you claiming that I didn't take care of this when this was the first instance when you asked me to do it? Make sure you keep these records. I don't care if you're renting to Mother Teresa. They will all turn on you. Now, let's move on. They're in possession of the premises. This deals with rent control property, which, by the way, is every property these days. And one of the tricks tenants will do is that they're planning on moving out. They'll have a stranger move in, and then the stranger pays you the rent and you accept it. You must look at every check that you get from your tenant to determine that it's from your tenant. You will not accept rent checks from strangers because tenants will then claim that you've now created a tenancy with this new tenant. And based on the law, as it currently is, they're going to claim that the rent remains the same, $742 for that 2-bedroom apartment because you accepted rent from this stranger. Well, it's actually not the case. We do have a way around that, but why get to that level? Do not accept rent from strangers. Now, the law does state that you have to accept the rent from a third party, but that third party has to send you a statement stating that, hey, I'm paying the rent for your tenant. I am not trying to gain any kind of a tenancy by paying this. I'm just merely helping out a friend. He's got to send a statement like that. Okay, the last thing is based on the state of affairs, based on statewide rent control and certain local rent control in certain properties. From now on, ladies and gentlemen, just do a month-to-month tenancy. Do not do a 1-year lease. Do not do a 6-month lease. Just do a month-to-month tenancy. It will give you a lot more power if the relationship goes bad and you want to evict the tenant. Okay, that terminates my discussion on the tricks, the common tricks that tenants play on landlords. Please listen to these tips, and quite frankly, you'll save yourself thousands and thousands of dollars. We're now going to open it up to the questions and answers. And remember that if you do want to talk to me and you're on the Zoom as opposed to YouTube Live, all you have to do is click on the electronic hand and I will definitely call you. We'll see if we can get to everybody today. Remember that these Zoom meetings, YouTube meetings are for informational purposes only. It's not intended as legal advice. And last but not least, if you have a current case with my office, please call the office if you want to discuss that, because this meeting is only for general questions on law. And we're now going to open it up to our old-time listener and fellow Zoom meeting person, and that would be Jim Polina. Say hello.
Hey, Dennis, happy Saturday.
It doesn't look like there's been much improvement on the ADU since last week. If you're
Oh, no, there is. You notice over here, the furnace is gone. See the pipe up there, and the water heater is gone.
Okay.
And hey, hang on, Bill. And we made a closet over here to put the furnace in.
Excellent.
This was that was the pantry. And then we scavenged. Hang on, Bill. Hang on. Sorry, Bill. Hang on. And this is the part of the closet for the small bedroom. We took over and made a laundry out of it.
Great.
It looks like
does this ADU have a bathroom? Oh, there it is. Good.
Yeah, that's the house. The ADU is going to be at the garage.
Okay.
So I had to get everything out of the garage.
Gotcha.
So, as a side note, I just have to say this is crazy. Shopping for HVAC, I got a high of $15,000 for new furnace and new ducts, and a low bid of $3,000. What a spread! My goodness.
All right, Jim, what's your question for today, young sir?
Well, based on last week, your security deposit. So these tenants who were great tenants, they moved out. They gave me a 60-day notice because they bought a house. And escrow closed early. They moved in. So they had 30 days of empty house here that they're paying for. So I decided to do this renovation during that time. They don't feel good about that. They don't feel good that they're paying rent on an empty house and I'm taking advantage of it. And they're asking for more money back from the security deposit.
You know, it was funny. I was driving in my car and listening. That's how sick I am. I was listening to this, my last meeting with you, and you didn't exactly ask that question, but I was thinking to myself, if you're going to hold them responsible for the last month's lease, because they moved out, but then you've already taken possession and you're only already doing the work, then I think I'm kind of in agreement with your tenants that they're entitled to more money, because it's one thing if you just closed it up and technically you're supposed to try to relet it, but you're actually doing work in there. So I think at this point you've taken over possession. So I think they have a point there, Jim.
Well, there is a caveat. It has been rented a couple days after they moved out, but they needed 30 days to give notice for their tenant or their landlord.
All right, so on that basis, then I think you're okay then, because you did try to rent it out. You did rent it out, but now you're doing the work to make it even better for them. But if they had wanted to move in immediately, could you have let them move in immediately?
Um, yeah, I could have, and I wouldn't have done this renovation if they wanted to, but
Right. So they were going to not, they were moving into the garage. They were moving, the garage is going to be a different person, correct?
yeah, way in the future.
Yes, okay. Yeah, so yeah, I don't see an issue there because you did try to rent it out. You did rent it out. So I think you're okay, but it is a very close call. Anyway, Jim, thank you very much. We are going to move on to Dennis Sibley, my trombone expert.
And yes, good afternoon. So,
Hello.
hello. I hope you hear me. Can you hear me?
Perfectly.
Great. Okay. I'm drawing upon your experience, please. I just had an incident. A Schneider tractor and flatbed damaged one of the block walls that encloses the dumpster. I received a police report. I contacted their insurance company. I have a claim. I'm just a little concerned knowing how insurance companies do not want to pay out claims. I just was drawing upon your experience and your wisdom in my approach.
Well, I mean, they don't want to, but of course they're going to have to. It's not really a landlord-tenant question per se, but just stay on them. Worst comes to worst, you could file a small claims court action against the trucking company who did the damage to the cinder block wall. But I would just kind of work with the insurance company. Obviously, you don't want it to go longer than a year. You want to file within the year.
In the meantime, I've got a damaged block wall.
Exactly.
So,
So I would make a claim to the insurance company that I'm going to get the wall fixed and you're responsible for the cost of it.
okay.
Because they're not going to fix it anyway. They're just going to give you money. So nothing prevents you from taking funds out of your own account and having that wall fixed.
Okay. Is there any way they can come back and say, sorry, we're not going to fix it?
Well, anybody can say anything, but that's why you have the ability to go to small claims court, right?
So who do I serve?
Well, the trucking company, find out the name of the trucking company. Then I would go to the Secretary of State for the state of California. You'll look up that corporation's name. It's probably a corporation. And then you'll see on that, when you click on that, and it's very simple to do this, it'll show you the agent of service of process, and that's who you sue. It'll give you a name and an address.
Servants of process.
Secretary of State for California, put in the corporation's name, and then you'll see where it says agent for service of process. Anyway, thank you very much, Dennis. We are moving on to Carranza. How are you today? Carranza, are you there? You need to unmute yourself. Okay, Carranza, well, we tried. We're going to move on to Kathy Campbell. How are you today?
Hi, Dennis. How are you?
I'm good, thank you.
Thank you. All I can say is that I have a very heavy heart that I did not discover you sooner. I'm not going to tell you about all the no-nos that I did. I have a single family dwelling that I'm renting out in Ventura County, and my tenant is a classic nightmare. Nothing really that he's doing. Well, he has been doing some things wrong, but it's this constant push and pull, and he's threatening me with, well, not threatening me, but he's building a case, I think, against me about certain things, like there's no fire door going into the garage and blah, 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 blah. All these things I will take care of because I know I'm legally.
Well, I'm not sure anything, I'm not into construction law, but I'm not sure that there's a requirement for a fire door. I mean,
Okay.
obviously your property was built to code. And if it was built to code and there's no outstanding code violations, then I don't know that that's required, but you'd need to check with either, building and safety for that area or with a local contractor.
Okay. Well, so as of last Monday, I had served him that 3-day repair or covenant form from your website. Thank you very much. He was in violation of the lease because he was letting his ex-wife stay in the house.
Why would he want his ex-wife to stay in the house?
Oh, you know what? It's such a long, convoluted story. Supposedly her air conditioning was out, and it was during the time that we had such horrible heat. And then the week prior to the temperatures dropping to 70 something, I said, is she leaving? No, she's staying until the air conditioning's fixed. It's like, well, I didn't agree to that. So I served him a 3-day fix or quit. And then the woman also brought with her five cats, bringing the grand total of the feline colony in my house to 7. So there were 7 cats living there, and I never authorized that. And I think
All right,
that
well, let me slow you down.
yeah,
Obviously there's violations of the contract, so you can proceed forward with an eviction.
even though he's fixed them now, she's moved out.
Well,
Which,
if she's fixed them and the cats are gone and they're not violating any term of the
I
rental
mean,
agreement, then there's nothing that you can do. Is this a
exactly.
single family home?
Yes, sir.
Only one house on the lot?
Yes.
Okay, so if there's only one house on the lot, and he's on a month to month?
Unfortunately not. We
Okay,
have
so
8 more months of
first of all,
torture
when did the lease commence?
in the 1st of June. So I have 8 more months.
Okay, so, and in that rental agreement, did you follow my lead by stating that this property is exempt from statewide rent control?
No, I
Sounds
don't.
like a no. Did you
I
use
didn't.
my rental agreement?
No, because I just found you last week,
Hmm.
unfortunately.
Where did you find me?
How did I find you?
No, where?
Oh,
Was
well,
that a bar or something? Where was it?
in North Hollywood. No, I just discovered you last week.
All right, well, thank you for listening. Well, first of all, when the lease is over, we can always raise the rent to market value. If you're renting out a single family home, make sure that your lease, use mine, but make sure the lease states that this property is exempt from statewide rent control, because if you don't have that box marked, what it means is that you're going to need to have cause to evict.
Okay.
That's why I always recommend a month to month. This way you wouldn't need cause, because for the first year for statewide rent control, you don't need a reason to evict. Unless you have that box checked, and then of course you can do it at any time. So, but at the end of the lease, if you're still not happy with him, and he might recover and become a nice person, unlikely, then we can always raise the rent, and that will probably have the effect of getting rid of him.
I don't even think I would offer it an extension, to be honest with you, but I have one more quick question. In the California Realtors Association lease that I used, I think it's section 7 pertaining to parking.
By the way, that lease has an exemption clause at the end of the lease. You might want to take a look at it.
Oh, so
and
that means that I can evict him without,
if the box was checked.
okay,
Okay,
okay.
so you said you had a parking clause. Go ahead quickly.
So quickly, it reads that, let me see this really fast. Where is it? It reads something about authorized vehicles, operable vehicles, and then it says except trailers, boats, blah, 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 which the way I read it tells me these are allowed except these types of vehicles.
I would concur in that. So is he parking an unauthorized
A
vehicle on the
trailer,
property?
and he said he's consulted with an attorney, and the attorney said, no, it means that these are allowed and these are allowed.
Okay,
Doesn't
well,
make sense to me.
I'd have to read the exact language in the lease, but the way you're sounding to me, it means that he's in violation of the lease. Anyway, you can always run that by us by calling the office. Thank you very much. I'm going to go back to Carranza, who I think has figured out how to unmute herself.
Yes, can you hear me? Can you hear us?
I can.
Okay, good.
It's
So
a
hi.
little tricky. Oh, look at that. That's Sam, right?
Yeah,
It's
that's
Sam, yeah.
and my name's James Carranza, and so since I'm driving, I'm gonna have him ask you the question on my behalf. Go ahead.
Okay. Dennis, so we have a situation where we believe somebody is a possible fraudulent claim filer with regard to property insurance. And we want to see the best way to communicate with the adjuster. Do we turn over the camera information of this guy supposedly falling down on acorns in front of the property? What is the best way to go about communicating with the adjuster? Is that the question?
The best
Because
way is
what
to get
happens-
yourself an attorney and have them review it.
Prior, correct?
Yes, that's the best way. Don't take this into your own hands now. But don't you have insurance?
Yes, I do. I have homeowners insurance. It's
Okay, so then deal with your insurance agent and their attorney and turn over the information and let them deal with it. That's why you have insurance. You don't want to deal directly with the other side. The other side's there only to hurt you. That's it.
okay. So
All
go.
right.
Okay, thank you.
Okay, thank you. We are going to move on to, and we are glad that we could get to you. Let's see. Bear with me. Let's move on to Robin. How are you, Robin, on a Saturday?
I'm good. How are you?
I'm good, thank you.
I have, first question is about the pink notice that's supposed to be posted on the building. I have a single family residence. That's the only building on the lot. And it's in LA City. And I did not post when the tenant moved in or back in 2023 when the law passed or the ruling passed. I'm about to serve them Monday with the rent increase, giving them 90 days. I'm going to have somebody personally walk there and hand them the documents. And I want to hand them that notice. Now, can I hand that to them, or do I have to actually nail it to the laundry room or something like that?
It's supposed to be posted in a conspicuous spot on the property. So says the morons who run the city council for the city of Los Angeles. So even though it's an $85,000 a month Brentwood house, you've got to have that notice posted in a conspicuous spot on the property. Now, I would take a picture of it because you know what the tenant's going to do in 12 seconds. He's going to rip it down.
And can it just be paper? And do I have to laminate it?
Well, you might want to put it in some plastic or something.
Okay, all right. and
You get
mail it to-
those baggies. Put it in one of
Okay.
those. They have
And
it kind of paper size.
It can be on the outside of the garage or something like that.
Conspicuous spot on the property, wherever that is.
Okay, second question. If rent control passes for single family residences, if Hawkins is rescinded in November and my rent increase doesn't occur until January 1st, what will I fall under rent control for this rent increase?
Okay, well, first of all, what we're talking about is Proposition 33. It's going
Right.
to decimate our industry. It's going to potentially take away vacancy decontrol where you can't even raise the rent after a tenant leaves to market value. It's also going to potentially impose rent limitations on single-family homes, townhouses, and condominiums. At this point in time, there is no limitation. Now, it's a misnomer that if Proposition 33 passes, God forbid, because everybody's going to vote no on it, that doesn't change anything. It's now giving each municipality, like the city of Los Angeles, the right to change their law dealing with rent stabilization. So I think you'd be okay because unless they're gonna pass the law and then roll back rents to the day of the election, I think you're fine. And I don't know how quickly these municipalities are gonna jump on the additional protection for tenants once this potentially passes, which it won't. Once again, no on 33, yes on 34.
Okay, thank you.
All right, and thank you, sir. We are going to move on to Jamie S. How are you today?
Hi, Dennis. Can you hear me?
Perfectly.
Thank you for the service you do to the community, Dennis. I have a quick question. I have a single family home exempt from AB 1482 in a incorporated city. It's similar to your previous question. I was initially planning to issue a 90-day notice to raise the rent about 15, 16%. However, I just recently discovered there is a state of emergency that enacts Penal Code 396 on September 11th. Does this disallow me from issuing the 90-day notice?
Okay, so sorry that you raised this question, but it is really a good one. Technically speaking, if the governor creates a state of emergency, the law states that you cannot raise rents until the state of emergency has been declared over. And that is under Penal Code 396. The crazy thing is this moronic governor specifically did that when it was just raining for, I don't know, a week or 10 days in LA County area. So he declared LA County as an emergency state. Total craziness on his part. But the way the law is written is like, well, if there's a state of emergency, then people are going to be taking advantage of it. Like people are going to be selling, a bottle of water at 7-Eleven for $500. That's not what we got here. And you can't even, the only way you can technically get around this would be to prove that based on your expenses, you were able to raise the rent. However, my position, which is a bold position, deals with the law called Costa-Hawkins, which we've quoted here. And that law states, notwithstanding any other law, you can raise the rent to market level or to any level for single family homes, townhouses, and condominiums. So I really don't care that the governor and under Penal Code 396 declared that it's a state of emergency. And by the way, last time I checked, didn't we have a heat wave here? You still got the state of emergency going? So, and I'm not sure if the state of emergency has been declared over it, but when he did do those rains, he did do it. But I don't really care because under Costa-Hawkins, let me repeat, the law starts notwithstanding any other law. So I don't think you'd be in violation of anything. And by the way, unless you listen to this, no one is going to know about that law and raise that issue. And how did you figure out that issue, sir?
There is a website, caloes.ca.gov, that lists the active state of emergencies. And there is one in the LA Bridge fire was declared September 11th. And that's supposed to be for at
LA
least 30
Bridge
days.
fire?
Correct.
So because one bridge got on fire, which I'm not even familiar with what that is.
That is correct. There is a state of emergency for LA County because of that incident.
Because of one incident on one, ladies and gentlemen, we got to get rid of these people, honestly. This is just a threat to all property rights. But I think we're still fine, Jamie,
Okay.
on the basis that that Costa-Hawkins says, notwithstanding any other law. How are you going to get past that, Mr. Judge, when we quote that for you? So
Right.
I think we're okay with that.
Yeah, I think it might be semantics because I was interpreting it as, well, if I give a 90-day notice, 90 days later, the declaration should be over. So I'm not raising the rent now. It's not effective until 90 days. But I don't know. I'm not a lawyer.
And on what basis, okay, let's think this out. On what basis does Governor Newsom declare that all of LA County is under a state of emergency because one bridge on September 11th, I don't even know about this bridge, to be honest with you, had a fire? Was this the one that was under a freeway and where homeless people were lighting cars on fire? Was it that one, do you think?
I heard it's some passageway that connects to the Inland Empire, and because of that, it was big
And
enough.
my response would be, so all
Right.
of LA County, Beverly Hills is under a state of emergency. All right, well, we see the ridiculousness. It's just his intent to make sure that nobody can, he's trying to put Proposition 33 on into play before it even passes. But
Right.
got to get rid of that guy.
And I was trying to preempt it with my 90-day notice.
I think you're okay.
Okay.
Anyway, thank you very much. Good question, even though I didn't like it. Randy, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello, Randy. What
I
is
have
that a
a,
picture of, by the way? Doesn't look like it's in California.
it's not, it's in out of state. My daughter sent me a picture while she was walking.
And which state? It looks like Alabama or Mississippi.
North Carolina.
North Carolina, beautiful,
Yes.
beautiful.
Thank you for answering my question. So I'm renting a single family home in Pasadena, California, and I followed your advice and sent a notice on September 1 to raise the rent to market value, and it'll be effective December 1.
Well, let's
Since
think this out logically.
Mhm.
September, October, November,
Oh, sorry. I sent it actually end of
August? August
August.
25th, I hope.
Yeah, exactly.
Oh,
Yes.
okay, good, because it's 5 days extra for mailing, so it's 90 plus 5. So for December, you would have had to have gotten it as of August 25th, just mailed it. But go ahead with your question.
Yep, and you're right. I had asked this question before, and so I followed your advice to the T. So because it was a more than 10% increase, I did the 90 days, and so yeah, it'll be effective December 1. I sent the lease to them. It was initially a year long, but the renters actually asked if they could switch to a month-to-month agreement, and I'm okay with that. But I'm wondering kind of two things. One, I'm using the residential lease agreement on your site, and it has like line 2 says term, and the premises are leased on this
Yeah,
term,
it
and
gives
there's
you
a
a choice between a month-to-month or a term lease. But
hmm.
right now, is the tenants under a fixed term lease that's still going forward?
Yes, they've been there for 5 years, and so
Okay, but are they on a lease now or is it month to month?
it turned into month to month after the
Okay,
lease.
so that's fine. And so what's the question?
So I sent them a new agreement because I wanted to raise the rent. And so I initially had the agreement say December 1, 2023 to 2024, but since they're wanting to do month to month, do I change the kind of term to like December 1, 2024? Like, do I put a month to
You
month
can
date?
make it month to month, but have a provision in the lease that says that as of December 1, this is what the new rent is. By the way, if they sign this rental
They haven't
agreement,
signed it.
but if they do, then the previous caller's issue dealing with the state of emergency would not apply in your situation at all because you're not, quote, raising rent per se by way of a change of terms. If they sign the rental agreement, then they're agreeing to the change.
I see. And so with a month to month, does that mean that I need to send them like a new lease every month, like with the
No, of
term?
course not. The lease just continues month to month until it is terminated by one party.
And then can I still ask for a 60-day notice if they do decide to move, or is that it's now 30-day notice because it's a month to month?
Okay, assuming your property is exempt from
Mhm.
statewide rent control, and that's why you'd want to check that box at the end of my lease.
Yes. Uh-huh.
Then if it's a single family residence, you can just serve a 60-day notice. It would always be 60 because they've been there longer than 1 year.
Gotcha. But they can decide to move with less than 30 days because it's a month to month
And that's
agreement.
true unless the landlord puts a term in the rental agreement, says that if the tenant wants to terminate the lease, they have to serve a 60-day notice. You can do that as well.
Even if it's month to month?
Yes, even if it's month to month, the lease says that if you want to terminate the lease, instead of a 30, you got to give me 60. Just like I have to give you 60, you got to
Mhm.
give me 60. Nothing prevents you from doing that.
Okay, so just check the box on your lease agreement that
But
says
it
month
is
to month.
exempt, and if you want to add in that extra term, feel free to do so.
Okay.
I'm going to move on, and we're going to move on to Margaret O'Brien. You're back again, young lady.
Yes, I'm back. Thank you. I have tenants in a rent-controlled a two-bedroom house. It's two houses on a lot, and they had a second child. And I forgot about being able to raise the rent 10%. And the child, I think, is about 3 months old now. Can I still do it?
Okay, first talk about the city of Los Angeles.
Yeah, San Pedro.
The city of Los Angeles states that under RSO, the Rent Stabilization Ordinance, you can charge an additional 10% for each additional person who joins the tenancy. However, there are some exceptions. The first child being born into the tenancy is free. If this is the first child, you can't do it. The
Oh,
second issue, which is more important, is you have to serve that notice within 60 days of that tenant occupying the property. So
Oh,
it's already been more than 60 days, so you would have had to have served your notice before that.
okay. Okay. Well, I that's the
By the
way.
way, was this the first child born into the unit?
It's the second child born into the unit. It's three children in a small two.
And the child's already 3 months old?
Yeah,
No, you're dead.
I got
O-
it. And
Okay,
then with regards to asking for repairs in writing, some of my tenants have been with us for 20, 25 years, and it was not in the rental agreement.
right, but we have a change of terms of tenancy, one of the free forms on my website, and it talks about that from now on, unless it's an emergency, I want all repair requests in writing.
Okay,
Or you
so
can
I
even
can-
do in writing or an email.
Yes, okay, I can add this and without messing up the old
No, of
rental.
course not.
Okay, thank you very much.
All right, thank you, Margaret. Let's move on to, I know Sylvia has an iPad. Say hello, Sylvia. Sylvia, are you there? Okay, Sylvia, we're gonna move on to Eric. Eric, gonna ask you to unmute yourself.
Hello, Dennis. I have a question regarding the mailing of rent increases. When you send it certified mail, is it okay if you exclude the requirement for them to sign to receive it?
Yeah, first of all, you can do it by regular mail. It doesn't have to be certified. You can also do what they call a proof of mailing just to show. I certainly wouldn't do it where they have to sign for it because then they won't sign for it.
Yeah,
So,
they never sign for it.
right.
Okay, so I could send it certified and but just have the electronic verification that I was put in their mailbox.
You got it.
Excellent. Thank you so much.
Thank you. Okay, we are going to move on to Fabiola. How are you today?
Hi, Dennis. Thank you so much.
Hello.
I'm well. Yourself?
I'm doing good.
I have a question. So it's kind of a general question. Well, it's a specific question, but I'll keep it as general as possible. The property is in Los Angeles. It's a single family home, legally a single family home. However, there is another property. They put an addition of 3 bedrooms, 2 baths attached to the original home.
Is that a legal addition?
Illegal.
Illegal.
Unpermitted, yeah. And there are tenants in that back house. So I'm
But
representing.
what about, is there tenants in the front house, the legal house?
There are tenants in the front, but they're going to be leaving. I have a buyer purchasing the home.
Okay.
And so the buyers in the tenants in the front are leaving, the ones in the back are staying.
And I'm sorry, what city?
Los Angeles.
Okay, go ahead.
And so I went onto the, zemis.org, and it says under RSO, it says no.
Right,
And-
because they're viewing it as a single family residence.
Right. So then my question is this: if the buyer moves forward with purchasing the home, how can he evict the tenants? It's an unpermitted unit and there are no rental agreements. There's nothing in writing. Would he have to pay relocation? And how can you go about it if it's the same address? There's only one address. The other unit is
Well,
like,
of course, there's only one address because it's an illegal unit. If you
Yes.
if you made it a legal unit, which he might be able to do and probably would be able to do, but first he'd have to get the tenants out. So number one, does he have to pay relocation? The answer is yes. The relocation can be anywhere from 25,000, from 10,000 to about 25,000, depending on whether there's children in the unit or somebody over 62, or if they have been there longer than 3 years. Is it doable? Of course, it's very doable. You have to call up Building and Safety for the City of Los Angeles, turn yourself in, so to speak. They'll send you an order to comply. With that order to comply, the purchaser can call my office and we'll file the application process with the Los Angeles Housing Department. And by doing that, we'll then be able to serve the tenant with a 60-day notice to vacate and pay them the relocation.
Okay, and so I know you said it's 10 to 25. So there are 5 people, none of them are over 62. They're all over 18.
And they have been there longer than 3 years or less.
They've been there 15 years.
Okay, so if I look this up real quick, and let's see here, bear with me.
Thank you.
And where is it? Right there. The relocation is $13,500.
$13,500.
Yep.
Okay.
Now I've got a question for you, Fabiola.
Yes,
Do you live in a medieval castle?
I wish.
Because look, it looks behind you, it looks
wish.
like it's pretty medieval with that
That would be
the
my dream house.
crosshairs in the windows there.
One other quick question. Can the buyer request for the seller to provide background checks on the tenants?
The seller, I mean, the buyer can request anything he wants, but you have no way of doing that for him.
Right. I mean, if the seller can't get them because he is the owner right now. So he can request that from the tenants that are
You
staying.
can't request that. The tenants are in possession. You can't ask them to do anything at this point. You know, they're in. What can you do?
Okay. Okay.
All right, take care. We're going to try to get through everybody. Well, probably not, but we're going to move on to Jonathan Kennedy. How are you today?
Oh, thank you. By the way, couldn't you ask that tenant for an Estole certificate?
Yeah, what if the tenant doesn't want to sign it?
Yeah, well,
And by the
right.
way, it's good to have in your rental agreement that it's a violation of a rental agreement if you don't fill out an estoppel. And I have
Yeah,
that.
mine
in
has that.
Yeah, I have that in mine as well. So, Jonathan, what's your
Okay,
question?
congratulations on your win over Basta recently.
Yeah, that was just
I have
on Friday, and Danny Bramson was in the hallway picking up tenants and jumped onto this one and then lost the case. So,
wow. Well, how much does it cost to go to trial with Basta for the landlord?
well, I can tell you that if you're dealing with other firms, you're looking at $20,000 to $25,000, and I can tell you ours is significantly cheaper.
Okay. I guess that's probably all I'm going to get out of you, right?
Call the office. We'll talk about it.
Okay. Thank you.
All right, if that's your question, we're going to move on to, wait, Jonathan, unmute yourself if you still had another question. Yes.
No, you answered my question. That was it. Thank you.
Okay, thank you. Okay, I didn't want to cut you off. Dave, how are you today? Mr. Dave, are you there? If you'll unmute yourself. There you go.
Hi, good afternoon, Mr. Block.
Hi.
Hi. So, if someone used your rental agreement and I know it says it request repairs in writing, do text messages count as in writing?
I think text messages are fine, because you can preserve them. As long as you can preserve it and show, I think that's actually really good. I think emails are good. I think it's better than, somebody delivering a written note to you, because this way you have definite proof. The same thing is true with a text message. So I like text messages. You can't limit it to just text messages unless the tenant agrees to that. But I think that's a very reasonable way of communicating and also preserving evidence.
Okay, if it wasn't clarified, would the court deem text messages as in writing or,
No, I would think that they would consider it in writing.
yeah, okay,
Yeah,
okay.
sure.
Just
In this
wanted to,
in this digital world, trust me, that's in writing. You know, they stopped teaching in school for young people script. Remember, we all learned script when we were in school.
yes,
Well, who
cursive, yeah.
uses script anymore? You know, you're just on your cell phone or you're typing a paper on your computer, and so script is outdated, in my opinion. Okay. Anyway,
And
ladies
also,
and gentlemen, I am going to call it a day today. Before I end this, though, I did want to ask for if you guys got any suggestions with regard to what topics for my opening topic you'd like to give. Please do so. If you're watching this on YouTube Live, you can leave it in the comments on YouTube Live. And I really like to get your suggestions in terms of what topics that you'd like to hear for us to kick off this show. Other than that, I want to thank everybody for joining us today for this Zoom/YouTube meeting. And next week I'll be here again on Saturday at 3 p.m. and appreciate all the good wishes. Thank you.